Hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, I am your host, Uncivil Law, a licensed attorney in Texas, Virginia, and before the U.S. Supreme Court, and I hope you're having a great day. For today's case, we turn our attention once again to Karen Reed. You'll remember Karen Reed. She was on trial for the murder of her boyfriend, but at least in my humble opinion, and many of yours, the evidence left a lot to be desired, and we weren't quite sure what was going on with the jury. Well, we now have some statements from the attorneys who said one of the things that was going on with the jury was that they actually voted to say not guilty. Wait, what? They voted not guilty? Well, that's what they're saying, at least. So we're going to read this thing, and we're going to read the affidavit and also read what the judge said about it, because the judge has already opined about this in the interim. So that's exciting. We have remarks from the judge already on this thing. So let's go ahead and read this and try to discuss it and see what we think about the whole thing. Okie dokie. So first of all, we have the motion to dismiss. Comes now Karen Reed, by and through undersigned counsel, and hereby moves this honorable court, pursuant to the 5th, 6th, and 14th Amendments to the United States Constitution and Article 12 to the Massachusetts Declaration of Rights, to dismiss counts 1 and 3, currently pending on the grounds the jury reached unanimous decision to acquit her on those charges, and alternatively, because there was no manifest necessity supporting a declaration of mistrial with respect to those charges on which the jury had agreed that they were not guilty, and therefore a retrial on such counts would violate double jeopardy. All right, so let's talk a little bit about what they're saying. All right, so first of all, they're saying the jury reached a verdict of not guilty, and the only way that you could have a mistrial that would not attack double jeopardy is what's called manifest necessity. So the classic example being the jury's hung, but there would be other examples like a witness, the jury was bribed. The judge has been threatened and has to be taken off the case. Something else that's, bizarre, out of left field, not typical. So the interests of justice essentially require it. It's a very rare thing. The most obvious way this happens is for the jury not to be able to reach a verdict. That's considered manifest necessity. It's not the only example, but it's some examples. So they say, well, okay, they reached a unanimous decision in their view to acquit, which if you accept the premise that they did that, then they can't be hung by definition. To be hung, they'd have they can't be both hung and unanimous at the same time. So, that doesn't make sense. And there was no other manifest necessity that would require setting this aside. So therefore you must enter the not guilty verdicts. Okay, fine. That's their theory. Let's press it on. The ancient right to a trial by jury is no mere procedural formality, but rather a fundamental reservation power to the American people. By requiring the executive branch to prove its charges to a unanimous jury, beyond reasonable doubt, the 5th and 6th Amendments seek to mitigate the risk of procedural or prosecutorial overreach and misconduct, including in the pursuit of pretend offenses and arbitrary convictions. Cool. Prominent among these reasons cited, this seems a little bit fluff to me, but follow whatever. We're going to go through why juries are good. I'm not sure why we need to go through why juries are good, but fine. Prominent among the reasons colonists cited in the Declaration of Independence for the break with Great Britain was that the fact that the Parliament and the Crown had deprived them, in many cases, of the trial by jury. After securing their independence, the founding generation sought to ensure what happened before would not happen again. As John Adams put it, the founders saw representative government and the right to trial by jury as the heart and lungs of liberty. Exciting. It follows that jury acquittal is entitled to the utmost respect in our criminal justice system. Yep. The double jeopardy clause provides that no person shall be subject to the same offense, be twice put in jeopardy or life or limb. Yep. The clause guarantees the state shall not be permitted to make repeated attempts to convict, thereby subjecting the defendant to embarrassment, expense, and ordeal, and compelling her to live in a continuing state of anxiety and insecurity, as well as enhancing the possibility that even though innocent, she may be found guilty. Perhaps the most fundamental rule in history of double jeopardy jurisprudence has been that a verdict of acquittal could not be reviewed, on error or otherwise, without putting a defendant twice in jeopardy and thereby violating the Constitution. Yeah, long story short, if you're found not guilty, that's the end of the game. That's the end of the game. Unlike some countries, I'm looking at you, Canada, but unlike some countries, our not guilties means something. Okay. Here, the very day after mistrial was declared, Undersigned counsel began receiving unsolicited communications from 3 of the 12 deliberating jurors indicating in no uncertain terms the jury had a 12-0 agreement that Miss Reed was found not guilty of 2 of the 3 charges against her, including the charge of murder of the 2nd degree. Why didn't they check the box, though? That's going to be my continuing question through a lot of this. Why didn't they check the box, though? Given the central importance that acquittals have had over our criminal justice system for hundreds of years, defense respectfully submits the jury's unanimous agreement precludes re-prosecution of Miss Reed on counts 1 and 3 and mandates dismissal. Alternatively, to the extent the court believes further factual development is required, the defense respectfully requests a post-verdict inquiry be held on the issue and the court authorize the defense to seek additional proof from the jurors regarding their having unanimously acquitted the defendant of 2 of the 3 charges. Yeah, none of this is going to happen. Let me just give you the spoiler alert. None of this is going to happen unless they have some pretty compelling state law that I don't know about. And presumably if there is, they're going to tell me. But none of this is going to happen in the absence of some sort of specific case law or specific statute. All right. It doesn't matter, right? The mistrial happened and the jury didn't check the box. So what they thought in their own heads is neither here nor there. Incidentally, by the way, this would be true if it were the other way around, right? Imagine for a moment, just imagine for a moment before you get, too upset about this. Imagine for a moment that, the jury said, we can't decide. And then the judge said, okay, I'm going to declare a mistrial. But then 3 of the 12 jurors contact the prosecution. And they say, actually, we were 12-0 to convict. We were 12-0 to convict on charges 1 and 3. Only charge 2 was the one we hung on. Okay? All right, so ask yourself, how comfortable would you be with the prosecution, the Commonwealth, coming to court and be like, they actually did agree, 12-0, Your Honor. They actually did agree. For some reason, they didn't understand the check the box, but I have sworn affidavits, even from all 12 jurors. How comfortable would you be with the Commonwealth coming back and be like, they really were unanimous, even said they were hung? And if you're not comfortable with it with the Commonwealth, you have to be not comfortable with it with the defense because, equal justice and all that stuff. So if they don't check the box, whatever they thought in their own heads is neither here nor there. Because, the jury could hypothetically change its mind in the process of checking the box, right? They take the vote 12-0, and, the proverbial hand is over the top of the form, ready to check it. And one of the jurors says, you know what, never mind, I changed my vote. Because until that verdict is actually read in court, until they actually, are confirmed it is their verdict, it's not the verdict. And incidentally, we've seen this happen too, by the way. We've seen this happen, although we haven't personally witnessed it, but it's been known to law to happen, right? So they check the box, guilty or not guilty as the case may be, and they come into court and they do the whole thing where they poll the jury. And every once in a while, it's been known to happen where they're like, hey, juror, is this your verdict? No, it's not. And it's like, oh, okay, well, go back and try again because it's not unanimous, right? So even if they check the box until they're polled or the polling is waived, right? Until the verdict is accepted, it's not a verdict. It's just a preliminary thought. So this is going nowhere unless they can prove some sort of corruption. Unless they can prove, and I don't know why the jury foreperson would refuse, because they apparently were of the same mind. The idea is 12-0, right? So unless the jury foreman refused to do it, or unless, I don't even know what the hypothetical would be, but this is not going to happen. The jury, for whatever reason, said, we can't make up our mind. And you can't go back after the fact and inquire about the jury. In order to do this, you'd have to put all 12 jurors under oath in order to determine if it's unanimous, because you'd have to determine it for all 12, right? I mean, so that's the only way you could do this in principle. And do you really want to shatter the province of the jury to put all 12 people on the stand? And one of them says no. And even what they say yes. Are you comfortable with the prosecution doing it, right? Again, we're back to the same hypothetical, right? They say mistrial, but 3 jurors contact the prosecution saying, as a matter of fact, we were guilty, 12-0 on that charge. Are you really comfortable with bringing all 12 jurors into the room and saying, we thought guilty. That was our real verdict. And being like, okay, I guess you're convicted now. Do you really after the judge declared a mistrial, you really okay with that? I bet you're not. So I'm just saying this is not going to happen. This is not going to happen. Okie dokie? Great. All right. Alternatively, to the extent the court... Okay, we read that part. All right. On June the 9th, Miss Reed was charged via 3 separate indictments with murder, vehicular manslaughter, and leaving the scene of an injury. A jury trial happened. On July the 1st, when the jury presented a note to the court, all counsel were ordered into the courtroom. The note was not presented to counsel for review, which is pretty weird. Rather, the court indicated the jury was at an impasse. Well, the jury, they read the note. I'm not sure what a difference it would have made if they had reviewed it, to be honest. Once the jury was seated, the court then read the jury note verbatim in open court, and without providing any opportunity for defense counsel to be heard, the court declared a mistrial and excused the jury. Yeah, I don't think they necessarily needed to do that. They didn't need to give an opportunity to be heard, right? Because they'd already had a couple opportunities to be heard on this issue, and ultimately, it's a question for the judge, right? It's a question for the judge. Is like, okay, are we going to do this or not? And we've already had 2 notes from the jury, and the judge is like, you know what, I'm good. And she's within her right to do that. She's within her right to make the decision. It's a perfectly lucid decision. So, she could have done the asking the counsel thing, but no, she didn't. So it's fine. It's not legal error. In short, neither defense counsel nor defendant consented to the mistrial, which would be another reason to say if they consented to it, if they agreed to it, then potentially you could do a retrial on that basis. And the court never ascertained from the jury whether its deadlock was in relation to 1, 2, or all the charges. I'm not sure it legally had to. That's the problem. The following day, on July the 2nd, Attorney Jackson was contacted by a juror in this matter who stated that she or he wished to inform them of the true results of the jury. According to Juror A, the jury unanimously agreed that Karen Reed is not guilty of count 1. Jury A was emphatic the count second degree was off the table, and all 12 jurors were in agreement that they were not guilty of that crime. The jury also unanimously agreed that Karen Reed is not guilty of count 3. Why didn't you check the box, though? Why didn't you check the box? This is going to be my continuing question. Why didn't you check the box? There was a lovely little box right under count 1, and a lovely little box right under count 2, and a lovely little box under count 3. Why didn't you check the box? If your opinion was not guilty, why didn't you check the box? All right, pressing on. Another day, on July 3rd, Attorney Yannetti was contacted by 2 different individuals who had received information from 2 distinct jurors. So this is hearsay now? We've got hearsay about what the jury did or did not think. Oh boy, this is exciting. All right, Informant B, I love how it's informant, sounds all so cloak and dagger. Informant B sent Attorney Yannetti a screenshot they had received from someone of a text message that the intermediary received from jury B. So it's double hearsay. It's a text message I received from a guy. So I received it from a guy who received it from the jury. Oh, okay. That's exciting. I guess technically it's triple hearsay since the juror is not in court right now, but never mind. Yeah, okay. Anyways. All right, in that screenshot, Juror B allegedly texted this following to intermediary B, who might be related to informant B. It was not guilty on the second degree and split in half for the second charge. I thought the prosecution didn't prove the case. I didn't think it either. No one thought she had hit him on purpose, even thought she hit him on purpose. Those are the same thing. No one thought she hit him on purpose or even thought she hit him on purpose. Those are the same exact thing. Okay, fine. Informant C had been in contact with another individual, intermediary C, who was a coworker and friend of Juror C. We're 3 degrees of Kevin Baking it over here, I'm just saying. And joined a Zoom meeting in which Juror Z discussed the trial. Informant C sent Attorney Yannetti the screenshot of his or her text message with intermediary C regarding what Jury C revealed in the Zoom meeting. Intermediary C. No consideration for murder 2. Manslaughter started polling at 6-6 and then ended in a deadlock 4 no, 8 yes. How do 8 people think that there's a vote for guilty on manslaughter? 8 people think Karen Reed hit him with the car? Really? 8 people think Karen Reed hit him with the car? Despite all this? My confidence in the jury system is becoming diminished. All that wonderful verbiage we had at the beginning of this thing, where we talked about the brilliance and wonders of juries and how we, fought a revolution and, shot at the king, basically to make sure we had juries forever. I don't know, man. I'm feeling a little less patriotic over here today. Not feeling that jury system. I don't know. Maybe the king had some points. Yeah, I don't know, man. All right, pressing on. Informant C. Interesting. If it were no consideration for murder too, shouldn't she have been acquitted on that count? Yeah. And hung on the remaining charges. Goes back to the jury verdict slip that was all that confusing. It wasn't that confusing. There was a box at the bottom of each charge. As one does. Also weren't there two lawyers on the jury? If the lawyers were confused, I don't know. Also, because they could have just sprawled not guilty on big letters. I don't know. They could have figured something out. Intermediary C. She should have been acquitted. I agree. Yes, the remaining charge where they're hung on. And the instruction paper is very confusing. Was it though? Okay. I mean, I don't think it was that confusing, but all right. All right. The jury unanimously concluded that Miss Reed is not guilty on counts 1 and 3, constitutes an acquittal, and precludes reprosecution. Yeah, no. I'm sorry, but no. No. They didn't check the box. They failed in their task. They failed. You had one job, jury. It wasn't. What constitutes an acquittal is not controlled by the form of the action in question. Okay. Rather, the court must determine whether the action actually represents a resolution, correct or not, or some of all the factual elements of the offense discharged. The mere presence of absence on a check mark is not dispositive. Well, I suppose that's true if other things were on the form. I'm willing to take a bet without looking at it that in Taylor 486 Mass at 482, when it said check marks on the form are not dispositive, what I'm willing to bet is true. And we could go look it up to see if I'm correct. But what I'm willing to bet is they didn't check the box, but they wrote it in. They wrote the words not guilty, or some other sort of indicia that they wrote not guilty. Maybe they put it on a question they sent to the judge instead of doing the form. They said, yeah, we're not guilty. We're good. Right? So yes, if the jury clearly and unambiguously communicated its intent in some other way, sure. But seeing as they didn't do any of those things, no. So I'm betting Taylor is not what we would say on point to this situation. I'm just guessing. They didn't have enough not guilty on each count? Yes, they did. Yes, they did. We could go look at the form again, but I'm pretty damn positive. Yes, they did. I'll tell you what, you send me a copy of the jury form that does not have a not guilty option on each of the 3 separate counts. Prove me wrong. You can prove it to me by sending it to me on my Discord. Show me where at the bottom of each count, it did not have a not guilty option. Show me that form. I'll wait in suspense. All right. By the way, this form doesn't exist, so don't get too excited. All right. Here the attached affidavits reflect statements by 3 debilitating juries, and the jury had reached a final unanimous conclusion that Miss Reed was not guilty on counts 1 and 3. There was nothing tentative about the jury statements. There technically is. I mean, it's their opinion. They're still of that opinion, but the jury's not of that opinion because the jury didn't communicate that opinion. So it's the end of the thing. Not guilty for 3, but not individually? Individually. I promise you. I promise you. At the bottom of count 1, there's a not guilty option. At the bottom of count 2, there's a not guilty option. At the bottom of count 3, there's a not guilty option. If I'm wrong, everyone gets a Sunday. All right. Anyways, pressing on. Let's see. All 12 jurors were in agreement that not guilty of such a crime. Yannetti, it was not guilty on second degree. No one thought she hit him on purpose, or even thought she hit him on purpose, which is the same thing. There was no consideration for murder too, and Miss Reed should have been acquitted on that count. Told this firm conclusion did not amount to an acquittal simply because it's not recorded on verdict form, would it be elevate form over substance in manner prohibited by the foregoing? No, not so much. No. There was only one not guilty box? Really? Are we doing this now? Are we doing this now? All right, fine. Hold on. There was only one not guilty box, really. Let's see if we can find a copy of the form. Excuse me as I now scroll to find a copy of it, wherever that would be. At the bottom of count 1, there's a not guilty box. At the bottom of count 2, there's a not guilty box. At the bottom of count 3, there's a not guilty box. There is a not guilty box with respect to each count. I know there is. I know there is. Even on the original form. Even on the first original form, there was a not guilty at the bottom of 1. There was a not guilty at the bottom of 2. There was a not guilty at the bottom of 3. There was a not guilty box on each and every counts, even on the original form. There was. I'm telling you. No, on the original it didn't? All right, we'll see if we can find a copy. We'll see if we can find a copy. One of us is going to look really foolish here in a second. Excuse me as I now try to Google in real time. I'm all right. Nobody worry about me. You got feeling that. Why don't you just let me be? I said, I'm all right. Don't nobody worry about me. Can't find. Why don't you just let me be? You're giving me the link? You can't give it to me in YouTube. YouTube does not allow for links. You have to give it to me in Discord. Okay, here's a link on Discord. This is an article. This has one page of the PDF. Okay. Yeah. All right. Hold on one second. This will be fine. All right. We can make it bigger. All right. Here's an article from WCVB from June the 22nd, in which they have pictures of the form. All right. Offense 1. Can you read this? It's a little hard to read. There you go. Offense 1, murder in the second degree. In the above titled case, we say the jury is not guilty or guilty as to count 1. Okay, great. Moving on to count 2. With respect to offense 2, manslaughter. In the above titled case, we say the defendant is not guilty. There's the not guilty box with respect to count 2. Moving on to count 3. Count 3, leaving the scene of an accident. There's the not guilty box with respect to count 3. Not guilty, offense 3. Not guilty, offense 2. Not guilty, offense 1. Each and every count had a not guilty box at the bottom of it. Okay? Can we move on? Thank you. None of you get Sundays. This is the original jury form, by the way. This is the original. This is not the modified one. This is the original. What Jackson or Unetti or whoever it was said was they weren't happy with this not guilty at the top of count 2 because they thought it was a bit ambiguous. And what they asked for was it to be rewritten so that it would say not guilty of the manslaughter offense or any other lesser offense. So they asked for this to be reworded. But this is the original wording. This is the original wording on the original jury form. And there's clearly a not guilty box at the bottom of offense 2, which is what I said in the first place. Get off my lawn. No, this is the original. I'm telling you, this is the original. The not guilty there was in the original. What Jackson wanted was the wording changed. The box was there the whole time. He wanted the wording changed to make it a little bit clearer that it was not guilty with respect to manslaughter or any other lesser included offense. The box was there, not guilty the whole time. He just wanted it reworded. Go look at it. Go look and see exactly what he said in court. That's exactly what he argued for. I watched it. I was there. Don't question me. I've been there since the beginning. That's not what you remember? Well, you just remember wrong. You remember wrong. Go listen to it. Go listen again. Go listen back to it. I promise you. I promise you. That's what he said. He said that he was not happy because it wasn't clear that the not guilty was with respect to every lesser included. Because it just had not guilty he said he was not happy that was not guilty for count 2, which implied not guilty for the parent charge. And then all it had was a list of options of guilty. And he thought that was a bit ambiguous. And what he said is, okay, in order to satisfy this, I'd like this rewritten. And the jury, and she agreed, but the not guilty there was there the entire time. I know it was there. You're just wrong. Sorry, Kurt, but it's you? No, it's not me. I know I'm right. The not guilty box was only on the top. Yes, and it remained only on the top of count 2. So it was the first listed option under count 2. And it remained the first listed option under count 2, which is correct, incidentally. You want the jury to be presented with the not guilty option first. That's preferable. So it was the first thing on the list for count 2, and then it remained the first thing on the count, even with the corrections. It didn't move. He just reworded it. Show us, prove us wrong? Okay. All right. Just watch it. I'm telling you that's what he said. I know that's what he said. I'm telling you, but we can watch it. Let's see if I can find it. Anyone happen to know where I can go find the thing? It would have been, was it the next morning? Was it day 2 of jury watch where he argued that? Okay, hold on. Karen Reed jury form. I'll just YouTube search for that. Okay, tense exchange after defense objects to slip. Okay, so there's this clip, which I think is their first time discussing it. And then, oh, here's the second time they discuss it. Okay, so I think these are the two clips we need. All right, let's go watch it. All right, so this is from when they first discussed it. Karen Reed trial, tense defense as defense objects to verdict slip. This is from June 26th. This is the same date that article was written. Okay, and here's what they said.
Yeah. Your Honor, I just saw the verdict forms, and as we discussed yesterday, the amendments that the court indicated it would make them.
Oh, no. Okay, I did not say I'd make it. I said I'd think about it. I said I was tired and I needed to think about it.
117.
All right, so why are we out here?
Your Honor, I just saw the verdict forms, and as we discussed yesterday, the amendments that the court indicated it would make them.
Oh, no. Okay, I did not say I'd make it. I said I'd think about it. I said I was tired and I needed to think about it.
What you said before you were tired and you needed to think about it was you agreed that there needs to be not guilty options for the subordinate charges under count 2.
I said that it made sense to me, but no, I did not change it upon looking at it because the verdict slip, this verdict slip as submitted to the jury is exactly how it always is in Massachusetts.
Can I ask you a question then?
He's arguing, his argument is there's no not guilty verdict for the subordinate charge to count 2, right? But there is the not guilty. It's always been there. He's just upset that it's not clear with respect to the subordinate charges. But that's the subordinates with respect to count 2. That's what he's saying.
I don't really care how it always is in Massachusetts. I care about whether or not it's appropriate.
It's appropriate.
Different things.
It's appropriate.
Let me make my argument, if you wouldn't mind, Judge, why it's not appropriate. For a superior charge, they have to decide that she is not guilty of the superior charge, and that is the starting point of whether or not she is guilty or not guilty of any subordinate charge, often called a lesser included.
So, I mean, he's clear, right? Because he's like, okay, the problem is they have to find not guilty of the parent charge before they can get to the subordinate charge. But the not guilty was always there. The not guilty was always there. He was just concerned that it wasn't clear that it applied to the subordinate charges. But it was always there with respect to count 2, which is all I ever said in the first place. Right? That's all I ever said. I said there was a not guilty under count 1, a not guilty under count 2, and a not guilty under count 3. And there was. His argument is, oh, the wording's just a little bit ambiguous. That was his argument. It's not clear that it necessarily applies to subordinate charges of count 2, which was never a claim I made in the first place. So I was right.
Once they decide that she's not guilty of the superior charge, now there's two additional charges that they've been instructed.
Right. Once they find she's not guilty of the superior charge, well, how do they do that if there's not a not guilty box? There must be a not guilty box. He's not even arguing that there's not guilty. He's just saying it's unclear with respect to subordinate charges.
They must decide whether she's guilty or not guilty of. How do they decide that she's not guilty of the first subordinate charge, involuntary manslaughter?
Okay. Anything else you want to say, Mr. Jackson?
I'd like an answer from the court. How do they decide that she's not guilty of involuntary manslaughter on that verdict form?
That's their decision to make.
And how do they make it if they don't have an option to check a box that says not guilty?
They don't check the box that says guilty, do they? And then when they go to the next block, they don't check the block that says guilty, and on the top, you're left with not guilty. Okay.
On the top, you're left with not guilty because it was there the whole time. All right, and then let's go see what he wants to do to cure it, right? What did he want to do to cure it? My claim was, in order to cure it, what he wanted was the wording changed. My claim was, okay, it always said not guilty. What he wanted was not that he wanted the not guilty option added. What he wanted is the wording to be changed. What he wanted is, okay, I want the wording to be changed so it says not guilty of both the manslaughter and any subordinate charge, right? And he wanted the wording changed, and the judge agreed, and all she did was change the wording. Let's see if I was right about that claim. I know I am, but let's go watch it anyway.
You may be seated.
Judge, we have a question for the jury. It's been marked QQQ for identification.
So, question, can we request the cert report detailing the search performed? So they can request it, but they can't get it. So I'm just going to say you have all the evidence in this case. We'll figure that out. I'll get some language from you. But Mr. Jackson, after our hearing this morning, I considered what you said. I went back and I read the jury instructions I gave yesterday. So I do appreciate the concern about the confusion this might cause the jury. I think it's easily clarified with the supplemental instruction. I don't think it's the verdict slip. I think it's how they're to follow the verdict slip. So what I've written up, this is a very rough draft. I'll read it to you. I'll take a break and let you consider it if you want. And this works out. I received this, I don't know, 15 minutes ago, and I've been, the letter, the question from the jury. So it seems a good time, so I was working on this. It seems a good time to bring them in for an answer to that question. And I would say, as long as I have you here, I want to clarify my instructions regarding your verdict as to count 2 of the indictment.
Go back to the day that he had a fit. We literally watched that 6 minutes ago or 5 minutes ago. We literally watched him having a fit about it. We just watched that just now. What do you mean go back and watch it? I just watched it. We watched it together. What are you talking about?
As I instructed you yesterday, there are 2 lesser offenses of that crime, which are involuntary manslaughter and motor vehicle homicide, felony, OUI, liquor, and negligence. Therefore, count 2 encompasses 3 separate charges, the most serious of which is manslaughter.
You can't stand
while
my
operating a
smugness?
motor-
I'm smug because I'm right. I'm smug because I'm right. I know I'm right. I'm smug because I'm right. I know I'm right. And I will prove to you. And you guys said, okay, prove it to us. I'm like, okay, I'll go prove it to you. So don't blame me for giving you exactly what you asked for. You're like, go prove to us. I was like, okay, I'll go prove it to you. I read the jury form. I showed it to you on screen. You're like, well, that wasn't what it was. I'm like, yes, it was. And you're like, that's not what they said in court. Okay, let's go watch it. I'm doing exactly what you said, but I know I'm right the whole time. I know I was right before we started. So yeah, I'm a little smug because I know I'm right.
Vehicle under the influence of liquor. In considering count 2, you should first focus on the crime of manslaughter while operating a motor vehicle under the influence of liquor. And if the Commonwealth has failed to prove that crime beyond a reasonable doubt, then you are to consider the remaining lesser included
NBC Boston, June 26th. We watched that. That's what we watched. This is from the 26th. This is from the 26th, June 26th, 2024. We're watching from the 26th. The previous clip was from the 26th. The one we watched before, the 3-minute clip, that's June 26th, 2024. It's dated right there. June 26th. That is June 26th. That's what he said in court. Now the judge is coming back and rethinking it. Same day, June 26th. It's what it's dated. Lord have mercy.
Sending order. The lead charge is manslaughter while operating a motor vehicle under the influence of liquor. If you find that the Commonwealth has proved all 5 elements, or proven all 5 elements of this charge beyond a reasonable doubt, then your verdict shall be guilty of manslaughter while operating a motor vehicle under the influence of liquor. If, however, you find that the Commonwealth has not proven all 5 elements of manslaughter while operating a motor vehicle under the influence of liquor, then you are to consider whether the Commonwealth has proven beyond a reasonable doubt the 3 elements of the lesser included offense of involuntary manslaughter. If the Commonwealth has proven the 3 elements of involuntary manslaughter, then your verdict shall be guilty on the lesser included offense of involuntary manslaughter. If, however, you find the Commonwealth has failed to prove beyond a reasonable doubt the crime of manslaughter while operating a motor vehicle under the influence of liquor, and the lesser included offense of involuntary manslaughter, then you are to consider whether the Commonwealth has proven beyond a reasonable doubt the 5 elements of motor vehicle homicide, felony OUI, liquor, and negligence. If the Commonwealth has proven beyond a reasonable doubt
Not
the 5
guilty was on the
elements of
original
motor
form.
vehicle homicide,
It was
then your
absolutely on the
verdict
original
shall be
form.
guilty of the lesser included offense of motor vehicle homicide, OUI, liquor, and negligence. If, however, the Commonwealth has failed to prove beyond a reasonable doubt all elements of manslaughter while operating a motor vehicle under the influence of liquor, and has failed to prove all of the elements of the lesser included offenses of involuntary manslaughter or motor vehicle homicide, felony OUI, liquor, and negligence, then your verdict must be not guilty to count 2.
Okay, so the judge says, okay, I've given what you have some thoughts, and I've come up with instructions to clarify this. Now, are they happy with this, or might they suggest some word changes to the not guilty that's already on the page? What will the lawyer suggest next? Might they suggest, instead of how about not guilty, what if instead of it said not guilty, what if it said something like not guilty of the manslaughter and also all lesser included? What if it said something like that? Will that be the next words coming out of their mouth? I'm pretty sure it's going to be.
May I have just a moment?
Yes.
Thank you, Your Honor. May I be heard?
Yes.
I deeply appreciate the court's additional clarifying language. I would simply ask for one very simple amendment, and that is at the top of the verdict slip that says the 2 words, not guilty.
At the top of the verdict slip, it says the words not guilty. His argument is that it's already there. At the top of the verdict slip, it says not guilty. But I'd like to change it. Here's how I'd like to do that.
We would ask that the verdict slip read not guilty of the offense charged or any lesser included offense. That's it. And I think that and the court's clarifying instruction would satisfy the defense. Not I think, I know it would. That's all we ask.
I don't think I know it would. That's all we ask. And he got what he asked for, and so he's happy. Okay. You were wrong. I was right. I've proven it. Can we move on now? Moving on. The Supreme Court's decision in Bluford is not to the contrary. There, a juror had reported during deliberations that the jury was unanimously against the charge of capital murder, but split on manslaughter. Okay, but the jury reported that. However, they reported it, but the jury reported it. Okay. The court sent the jury back to deliberate, and while the jury remained unable to reach a verdict, it declared a mistrial. The Supreme Court rejected the defendant's argument. The double jeopardy clause prohibited re-prosecution for capital and first-degree murder. In doing so, the court relied heavily upon lack of finality of the jury report. The jury's deliberation had not yet concluded and went back to jury room to deliberate further. So in this case, that they're referring to, in this case, Bluford, apparently what happened in Bluford was the jury came back with some not guilty verdicts and some we don't know. That trial judge in that case, in the case of Bluford, said, I'm not going to accept any of your verdicts at this time. I want you to go back and deliberate. So they came back not guilty. The judge said, I'm not going to accept that. Go back and try again. And then apparently they did that. And the judge then declared a mistrial. And the defense in that case, Bluford, said, wait a second, the jury came back not guilty. Unanimously, they came back not guilty. And the Supreme Court of Massachusetts said, well, no, not so much, because the judge sent them back. So the jury's deliberation not yet concluded and went back to deliberate further. So even where the not guilty box was checked, The judge could have said, no, I'm sending you back. They could have, and declared a mistrial. That would have been an option, says the Supreme Court of Massachusetts. That's what they said. Contrasting or attempting to contrast, they say, here by contrast, the jury statements reflect a final determination that persisted through the end of deliberations, except they don't, because they were never communicated while the trial was still ongoing. And so they don't count. Even assuming arguendo and contrary to the foregoing, this court finds a retrial will be not prohibited under Bluford. This court can and should afford broader protection under state law. Well, that's a policy argument, and maybe they should, but they don't have to. There's no precedent to support that proposition. I hate you so much, Carol. I've proven it. Go away. Any further argument that there was not a not guilty will result in a timeout. I have gone through it. I've shown you the verdict form. I've gone through it and shown you the argument. I've proven it. Any further argument at this point will be deemed trolling and you'll be banned. Thank you. All right, pressing on. The double jeopardy clause affords a criminal defendant a valued right to have her trial completed by a particular tribunal. Thus, when a mistrial is entered without the defendant's request or consent, retrial is impermissible unless there's manifest necessity for the retrial. See, for example, hung jury, judge is threatened, the jury was bribed, etc., and so forth. Here, Ms. Reed did not consent to the declaration of mistrial, which would also be another way to get around this problem. If they consent, then they waive the double jeopardy issue. Okay. Absent the defendant's consent, state and federal double jeopardy protections bar, as a general rule, retrial of a defendant whose initial trial ends without a conviction. The rule is rooted in the importance of the defendant being able to, once and for all, conclude her confrontation with society through a verdict of the tribunal that she might have been able to dispose to her fate. Okay? Accordingly, the heavy burden of establishing manifest necessity to justify mistrial is exclusive on the Commonwealth, which is true enough as far as it goes. Before a court declares a mistrial for manifest necessity, counsel must have been given a full opportunity to be heard, which they had been in this instance on prior occasions relating to the same issue, right? Because the issue is the jury deadlocked, right? And they had argument on this issue before, so I don't think they necessarily had to have argument again. They've been heard on the issue. And the trial judge must have given careful consideration to alternatives, which they arguably did because they sent them back at least twice. So I think both those standards are met. Okay. Only the jury foreman got the tick form. There's only one jury form. There's only one form. All right, Dr. Tracy gets a timeout. I am not fucking around. Okay, we'll time you out for 10 minutes. Come back and when you learn to read harder. Okay. The record is independently lacking on the second prong as it reflects no careful consideration. I disagree. Here, there was one obvious alternative: to simply ask the jury to specify the charge on which it was deadlocked. They could have done that, but they're not saying any case law that they had to. Had the court done so and the jury articulated its verdict consistent with the statements of A, B, and C, double jeopardy implications would have been clear and decisive. Yes, if they had done that, but I'm not sure that they had to. Indeed, with virtual unanimity, the cases have applied collateral estoppel to bar the government from relitigation a question of fact that's determined in defendant's favor by a partial verdict. That's fair enough. That's true. When a jury hands down a partial verdict, a final judgment is rendered on counts in which the jury has reached an agreement. Yes, that's fair enough. And that's true. Dark King says a judge can find the jury to find them guilty. No, that's not what it said. No. It's then that in that case, they came back with not guilty verdicts and also undecided. And the judge refused to accept any of them and said, go back and discuss the whole thing. It was not a complete verdict. It was not a complete verdict. So no, they can't force them to decide guilty. That's not what I said. It's not what the case said. Okay. The Supreme Court's holding in Commonwealth versus Roth that courts should not request partial verdicts on lesser included offenses charged in a single count does not pertain here. Okay, so yeah, if it's a single count, you shouldn't ask them to render decisions on lesser included. But we have 3 independent counts, so that doesn't apply. As the Roth court acknowledged, inquiry into considering partial verdicts on lesser offenses that have not been separately charged carries a significant penalty for coercion. Yeah, okay, so if it's one charge with subcounts, then don't do this. But if it's separate counts, you can. There's a difference. And there are 3 separate counts, one of which has subparts. Okay. Such an inquiry, in effect, implies the jury should consider conviction on the lesser count. No similar danger is present, whereas here, the jury is asked to return 3 separate verdicts on 3 separate counts, which are all legally independent, because that's what they are. They're independent counts. In this circumstance, where a jury reports a deadlock without specifying the counts on which its recent impasse, it's straightforward, and defense contends constitutionally required, to ask where the deadlock requires some counts, as to all counts. Indeed, the Supreme Judicial Court has explicitly stated where a complaint or indictment in multiple counts charges multiple crimes, a general verdict could be returned as to one of the counts despite deadlock on other counts. It can be, but we also had a case dealing with it doesn't have to be, right? Because we had that case. So the judge can accept a partial verdict. The judge does not have to accept a partial verdict. And there's no case that they've cited that says the judge has to inquire about as to which parts they are deadlocked or not, because it wouldn't matter either. It wouldn't matter anyway, right? Even if the judge did inquire and they said, okay, we have verdicts for 1 and 3, not guilty. She could be like, okay, well, taking note of the Supreme Court precedent of Bluefield, go back and deliberate harder because you haven't reached a verdict as to 2 yet. So even if she had done the inquiry and they had said not guilty, she could still order them to keep deliberating. She can accept it, but she doesn't have to. It's up to her. There's no case that requires it. That's what it says. Okay. Incidentally, though, the case law is not clear what happens if she does that and she gives the Allen charge and everything else, and they're still deadlocked on something. So, like, if they had come back not guilty as to count 1 and 3 and undecided as to count 2, and she sent them back and they were still undivided after giving the Allen charge and everything else, and they were still divided, and they still said, no, we've gotten to the end and we're still like not guilty 1 and 3, but we're unsure on 2. Does she have to accept that, or can she rule the whole thing a mistrial? The case law doesn't seem to be clear on that contingency. So not clear, apparently. Okay. Yeah. Okay. Undersigned counsel did not initiate the communication with jurors A, B, and C, which resulted in the disclosure. Some states don't allow for that contact. Florida doesn't allow for that contact for reasons that pass my understanding. But most states, the lawyers can, so I'm not sure why they said it. But yeah. So Massachusetts law permits a jury to return a partial verdict on some but not all counts. Okay, fair enough. So maybe at the end she has no choice but to accept the partial verdict. Maybe that's something at the end she has to accept. Fair enough. Maybe that's what the law says. Okay. Should the court find further development is required, the defense respectfully requests the jury court conduct a voir dire section and or evidentiary hearing to substantiate the evidence of the acquittal. Should the court seek the affidavit of each juror, which they would need to do at a minimum, because we need to figure out whether or not this is true of all 12. So even A, B, and C all testifying, yeah, it's true, is not going to get you there. You would need to depose all 12. Assuming that you could do this, which I don't think you have to, and I don't even think it's warranted by the facts, to be honest. And again, it's like, if you think it is, then you also have to deal with the opposite contingency, right? This is where I think that people sometimes make a mistake because they haven't thought this all the way through. They're like, okay, if this is true, and the jury did really have this opinion, then she should be acquitted. It's like, yeah, but okay. But it's like, are you really ready to apply that both ways? Are you really ready for the court to say, okay, this is mistrial, and then 3 jurors contact the prosecution? It'd be like, as it turns out, we were all in agreement. And we do actually think guilty. And so we bring all 12 jurors back and we swear them under oath, and now it's suddenly a guilty verdict where before it was a mistrial. It's like, are you comfortable with that? It's like, if you're not, then you're trying to play both sides of this thing. And that's not fair. So, I'm just saying. Yeah. And maybe you are comfortable with that. I'm just saying you got to think this through both ways. You got to think about what that would really mean and make sure that you're really comfortable with that both ways. Because, what's fair is fair. Like, All right, let's see. The Supreme Judicial Court has held, because of the importance of the issue, juror bias is a legitimate subject for post-verdict inquiry. It is similarly a fundamental tenet of our system of justice. The defendant need not be retried for a crime on which she has been previously acquitted by a jury. A defense submits the post-verdict inquiry is essentially warranted in the present context. No. Just as the court in McClop approved questions as to the existence of racial bias, but when in completely different circumstances that don't really apply here, questions about a matter more attenuated from the content deliberations, whether the jury had unanimously concluded they were not guilty, do not invalidate the heart of the deliberations. Okay, for the foregoing reasons, they respectfully request an order dismissing count 1 and 3. No, you're not going to get it. You're not going to get it, and I don't think the law requires it, and that's the end of that game. And it seems self-evident that there was at least one juror on this jury, because there is no way on the face of this earth that those juror questions were not written by a lawyer. There's just no way that it wasn't a lawyer who wrote those, because they were written with like all the buzzwords and trappings and everything. I was half surprised it didn't include citations, So if there was a lawyer on that group and they didn't understand they can check the not guilty box, my sympathy for the jury goes way down. And I'm just back to the jury's a bunch of idiots. There's a not guilty box right there, man. You could have just checked it, and that's just the same. On principle, I'm okay with the latter acquittal. I'm not okay with the latter conviction, which would always err on the side of acquittal. But in this hypothetical, we're just trying to give effect to what the jury really thought, right? Because the jury really thought convict, apparently. So we're just simply giving exactly what the jury thought, which is yeah. So I'm not sure your thing works, but fair enough. Did they each have a form? No, there's only one form. There's only one form to avoid any confusion. But they could have asked a question, right? They could have asked a question. Like if the issue was confusion, it's like, can we return a verdict on some counts but not all counts? They could have asked a question. Like, can we do that? Or we have a verdict on some counts but not other counts. What do you want us to do? But they didn't ask that question either. Like, so my sympathy for the jury goes way, way down here. Just incredibly down. All right. All right. As to Mr. Yannetti, he wishes to provide the following information. Okay, on July the 3rd, I received communication from 2 different individuals, Informant B and Informant C, who had received information from 2 distinct jurors, Juror B and Juror C, both of whom have been deliberating in this case. To my knowledge, Informant B and Informant C do not know each other. On July 3rd, Informant B sent me a screenshot she received from someone, hereinafter named Intermediary B, so multiple levels of hearsay, it's just always exciting, of text messages that Intermediary B had received from Juror B. In that screenshot, Juror B texted the following to Intermediary B. It was not guilty on second degree and split in half for the second charge. When the judge sent us back with the Hernandez thing to look at the other side, it turned into a bully match. I thought the prosecution didn't prove the case. No one thought she hit him on purpose, or even thought she hit him on purpose, which is the same thing. They gave us free counseling forms when we left. Neat. Based on the first name of Juror B given to me by Informant B, I believe I'm able to positively identify which juror he, she was and confirm that he, she was a deliberating juror. Oh, based off of first name. That's exciting. On July 3rd, informant C contacted me to say that he, she personally knows juror C and they used to work together. Informant C and juror C also have a mutual friend, intermediary C, who is a current coworker of and friend of juror C. Informant C told me that he, she had posted something about Karen Reed case on Facebook on July the 1st. He, she told me that he, she believes the post led intermediary C to text him and inform him that juror C was a deliberating juror on this case. Informant C told me that he, she thereafter reached out to juror C via text message and discussed his or her experiences as a jury in very general terms. They discussed what an exhausting experience it was and that juror C was relieved it was finally over. Intermediary C told informant C that juror C is supposed to be for cookie, and I do not have any cookies. I'm very disappointed. Informant C told me that intermediary C was reporting her during the exchange what juror C had revealed during the Zoom meeting. The exchange reads as follows. Intermediary C, no consideration for, so this is coming from the intermediary C. No consideration as to murder 2, manslaughter started polling 6-6 and then ended deadlock 4-no, 8 yes. That's it's intermediary's understanding, apparently. Oh, that makes me feel better. He, she was very consistent the fact that they could only consider things that were admitted to evidence. That is true. Ultimately, he, she voted no because the cause of death was twofold. Hypothermia and head injury, of which she was convinced the vehicle did not cause both. That's really dumb. If that's their reason. That's incredibly dumb. That's just insanely dumb. If you assume... That's just incredibly dumb. You are responsible, obviously, for anything that's a natural consequence of the thing you did. So if you assume that Karen Reed was hit by the car, and if you assume the head injury was caused by the car, and if you assume that he was debilitated by the car, then yes, the hypothermia counts as being caused by Karen Reed. I mean, duh. Of course it does. This is stupid. This is insane. Of course it counts. She's the one that caused this entire chain of causation to occur in the first place. And it's a foreseeable consequence that someone might get injured and hurt and perhaps freeze to death. So, you don't even have unforeseeable and you don't have intervening cause. So if they were down to, well, the hypothermia also killed him and she's not responsible for that, that's also dumb. That's just wrong. And the jury is an idiot. Can I explain the not guilty at the top of page 2 and not next to each option? Can I explain it? I mean, there was one not guilty. So the option was the top count, which is manslaughter. And so you have not guilty, and then you have all these subordinate charges. And Jackson was upset that he thought the wording was a little bit ambiguous and he wanted the wording changed. So there was still one box for not guilty. All he wanted was the wording changed, which he got. So they didn't add new boxes. They just changed the wording on the one box. So I don't know. That isn't what you're talking about, then I didn't understand the question. Barbara Thomas is a member for 15 months. Then I didn't understand your question. What was your question? You feel like they shouldn't be able to do lesser included, but they're all implicitly charged. So, okay, but that's not the law. Look at page 2. I did look at page 2. You want me to look at page 2 again? What about it? Yeah, so page 2 has offense to manslaughter while operating a vehicle under the influence In the above titled case, we say the defendant is not guilty, guilty of the offense charged, guilty of a lesser included, guilty of a lesser included. Okay, what's your question? Jury got confused, but they did give him a new jury form that apparently was satisfactory to the defense. So I don't understand your question. The defense got what it wanted. The defense thought it was unclear, and they said, here's what we want, and it will satisfy us, and they got what they wanted, which satisfies them. So I'm not sure what question you're asking me. They added a not guilty box? No, the fuck they didn't. No, the fuck they did not add a not guilty box. Fuck you. Right. Let's see. All right. She was very consistent of the fact that they could only consider things that were admitted into evidence. Ultimately, she voted no because the cause of death was twofold, which is a really stupid reason to vote not guilty. The whole jury felt very intimidated by Higgins' presence at the end. He's sure not what she's going to do. She's going to lay low for a couple days and see where it takes him or her. Hasn't ruled out anything. The jurors all have a group text going. That group text should be amazeballs if it ever makes it into discovery, which it won't, but it will be amazeballs if it ever does. Informant C, interesting. If there's no consideration for murder 2, she shouldn't have been acquitted on that count. She shouldn't have been acquitted on that count. You mean she should have been? That's the wrong verbiage. You're an idiot. Informant C. If there's no consideration for murder 2, shouldn't she have been acquitted? That's a question. And hung on the remaining charges. Sue Candrell says, some of the charges tonight are negative trolls. I'm angry at this blatant injustice. The trolls are making it worse. Can't zap them. Yes, our mods are more than free to zap trolls. Especially because I've proven it. I've proven the trolls wrong. I showed you the original form. I showed you the argument in court. I said, and it was exactly what I said. It was exactly what I said. I was right. I knew I was right. And then I proved I was right, and still some people aren't happy. So yeah, you can block trolls because I'm tired of dealing with people after I showed it. You know? The not guilty box was added. Goodbye. Fuck you. Goodbye. All right. She should have been acquitted, I agree. Yes, the remaining charge was what they hung on, and the instruction paper is very confusing. What a great experience for him or her. Amazing that they let the Alberts in that day. She felt very honored to be part of it. She was redacted physical description of juror C. Everyone else from a professional walk of life. They all got along and never heated. They agreed to disagree and respect each other. That's the way it should be. Knew it was an intelligent jury. They'll be studying this case in law programs for a year to come. I'm not sure about that, but okay. See how not to investigate and try the case. Well, that part maybe, yes. If they all agreed on no for murder 2, they should have made that clear to the DA and the court. Yeah, that would have been really, really nice. It's basically a case of double jeopardy. She's retired. It would have been had they made it clear to the court. But no. Absolutely not. Based on description of juror C, I'm able to identify it. Fine. That's good. Day Y. Let's see what AJ has to say before we get to what the judge had to say. On Tuesday, July 2nd, I was contacted by juror A, true name and identity withheld. Based on my conversation with juror A and the jury's description of who she was, where she here was seated, and certain identifying information disclosed during voir dire, I'm able to positively identify which juror they was. Juror A told me that they were seeing inaccurate reports about the split among the jurors relating to the mistrial the court declared the day before. PJ Tellers, you're welcome. I'm happy to help you out. Thank you very much. Juror A stated that when she wished to be respectful of the privacy of such deliberate process, but did wish to inform me of the true results of the process. Juror A believed that it was important to disclose such results because they believed those results significantly impact Miss Reed's rights. Is it basically not jeopardy because Bev handled mistrial sloppily? I'm not sure, strictly speaking, that she did. I do not believe she handled the mistrial properly. No. I'm critical of Judge Bev for any number of reasons that you'd like to bring to the table, right? But of course, being a good commentator, I'm going to try to give you appropriate analysis regardless of what I think, generally speaking. I don't see a legal problem with the way that Bev handled the mistrial. She sent the jury back at least twice, one of which with the Allen/Rodriguez/whatever they call it charge up there in, Massachusetts. And they apparently were not guilty, or apparently hadn't checked any box. And so she's like, okay, they're just at an impasse. And she read the juror's note. She read it in open court. So I don't think she made a legal mistake. By giving a mistrial. She could have asked for more clarity. She could have asked, are you hung on counts 1 and 3? Or something else. Like, she could have asked that, but there's nothing in the case law that they cited that she has to. She could have, but she doesn't have to. So I can't find a legal error. So yeah, I don't see, and this motion doesn't make sense to me. So not based on what's presented, if it were the case that the juror were saying, all of us really wanted to check the not guilty box and the jury foreman wouldn't let us. And, he was holding it hostage and he was, threatening us. And, if we're something like that, maybe, but not based on what's here. And besides, they actually said the contrary of that. They said they were respectful and agreed to disagree and all the rest of it. They're not talking about like the jury foreman, threatening people, or they're not talking about anything like that. So I don't think Bev made a legal mistake in the mistrial. And I don't see this motion going anywhere. This motion is garbage balls. This motion is garbage balls. I think the case should be dismissed for other reasons, but not for this reason. This reason sucks. Juror A told me the reason that deliberations with jury unanimously agreed Karen Reed is not guilty of count 1. Juror A was emphatic that count 1 was off the table, and all 12 jurors were the agreement she's not guilty. Juror A told me shortly following the determination count 1, the jury also unanimously agreed they're not guilty of count 3, which I'm not sure how that necessarily comes into play unless they don't think she did the accident, at which point I'm not sure how they're split on count 2, but whatever. On July the 1st of 2022, when the jury presented a note to court, all counsel was ordered to the room. The note was not presented to counsel. Rather, the court indicated the jury is in an impasse. Yes, that's true, but I don't think that's legal error in this mistake, in this instance. They had been heard on this issue before. It's the same issue that had arisen. It's a question of when do we meet the threshold. We know what the parties' positions are. We're going to make a decision. It works out. Great. Yeah. Sue says, I zapped my first troll. Blocked. Great. What are my grounds the case should be dismissed? No reasonable jury could convict. That's the reason I think it should be dismissed. It should have been dismissed at the end of the state's case. A judgment of acquittal should have been entered. No reasonable jury can convict. It's insane. Apparently 8 not reasonable jurors are of the opinion they can convict, which is scary, but not the first time this has happened in law. That's what appeals are for. And arguably in the panoply of appeals in which, batshit crazy jury verdicts have been overturned, this is not even the most batshit crazy of them. There have been some batshit crazy convictions over the years, as you might appreciate. So it's like, this is batshit nuts. It's not the first time, and it's arguably not even the worst time. But this definitely falls in the batshit crazy to convict category, at least in my mind. Scooter54 says, why quit on leaving the scene but not the OUI manslaughter charge? That's like what I said. I don't know, man. It doesn't really make sense to me. I don't get it. Let's see. Yeah. Please give us an example of batshit crazy. I'm not sure I can do it off the top of my head, but there definitely been some batshit nuts verdicts, man. Yeah. In the history of law, you can appreciate. All right. Okay, so anyways, additional statement on that, and now we can get to the judge's decision, and then I'll answer some questions or something. Order of impoundment. Nice. We're impounding the case like we're impounding a car, I guess. Not clear how much you have to pay for the impound yard to get it out of impoundment, but okay. The judge is impounding the case. Exciting. The Supreme Judicial Court has recognized that the safety of jurors is critical to the fair functioning of a judicial system, and the judicial system owes them the highest degree of vigilance for their safety. This case has garnered significant and divisive attention in Massachusetts and across the nation. The trial was live streamed on local and national broadcasting channels and here on Uncivil Law. The proceedings continue to be the daily subject of commentary on various social media platforms. People associated with the case have been charged with intimidation. The court, that would be Turtle Boy, for example. The court acknowledges that the names of impounded jurors who render a verdict in a criminal case must be retained in the court file be made available to the public. The juror in this case did not return a verdict, however, and the court concludes that there's a real and present risk of harm to the jurors and integrity of their service. Consequently, the court finds good cause exists to impound the list of identifying names of the jurors in this case. The court further concludes that there's a risk of immediate and repairable injury should the list be made available to the public at the time. This order shall expire 10 days from this issuance unless otherwise ordered by the court. So the court put a freeze on releasing the jurors' names for 10 days, pending further whatever. Turtle Boy didn't intimidate anyone. I didn't say he was. I said he was charged with it. Or I meant to say that, at least. So, yeah. All right. It's not. I guess it's not a rumor. It's not a rumor. He was charged. I mean, I know he was. I read the indictment. What about a FOIA? No. First of all, FOIA only typically applies to the executive branch, and this isn't the executive branch. So FOIA probably doesn't even apply at all. Because FOIA is typically for administrative records, and this is not an administrative record. Shannon, 1989, has been a member for 6 months. You want caramel on your sundae? None of you are getting a sundae because you all failed. None of you get a sundae. Yeah, Kurt's not defaming. Kurt takes no position. I do not take any position on whether Turtle Boy did or did not intimidate anybody. I don't know enough to take a position on it. I simply note he was charged with it, or that's all I meant to say, is that he was charged with it. So I take no particular position on whether or not he has intimidated or not. I don't know enough things. And I'm already deep enough into this case. I don't really want to get into the finer points of Turtle Boy. I'm going to take a pass on that one. So, you guys can figure it out. Is it common for a case to be impounded? I've never heard this verbiage before, but it's not unusual for jurors' names to be restricted by law for some period of time. I believe the jurors in the Depp case were restricted for a year. So I don't know. Batshit crazy appeals. What a great idea for a series. Maybe short videos. Thanks for sharing your brain with us. I can breathe again. You're welcome, Sue. How did I fare with the storm? I lost power for about 12 hours now, a little bit longer. I lost power for 20 hours or something. But we're back. My UPS kicked in like a champ. Kept my power on to my PC for like a half hour so I could shut it down gracefully. And it worked because I plugged my internet into it and I had internet access. So the internet that was sort of an open question, right? Will the internet continue to work even if the power goes out? The answer is yes, apparently. So apparently wherever that internet is plugged into, in the phone network system, there's a power backup for that system. So my internet continued to work despite the power loss, which was pretty cool. So I have my router plugged into my UPS, and I have my PC and like camera plugged into my UPS and our stuff. So it's all good. I mean, it's not unusual that like a phone line will stay on despite a power outage because those usually have independent backups. So I wasn't clear whether or not the internet would. So yeah, I was probably the only person with internet in my building At least wired internet, because it was still working. Riska Sky gives $5 a quick TLDR of Turtle Boy. For some of us who have never heard of him, beyond someone trying to intimidate him by hanging a poor turtle outside of home, I don't know enough about him to comment. I really don't. I wasn't trying to be cute. I don't know anything about him. I really don't. I just read the indictment and read that he was charged with things. I don't really know anything about him. I watched, I think, one live stream or two live streams. He seems like a eccentric character. Can I look up MSC PR27B link on Discord? Okay. I'm still back. I'm still back with if there was a lawyer on that jury and they didn't know that they could check the not guilty box. They didn't know they could do that. I am shooketh. I am shooketh. Link on Discord? I don't have the link. Where is it on Discord? I don't see it in general. And I don't see DM on it. Where is the link? Maybe the lawyer is one of the ones who are guilty on the lesser. I don't know how. Video discussion? Okay. Okay. Several offenses or defendants. If there are two or more offenses or defendants tried together, the jury may, with consent of the judge, at any time during its deliberations, return or be required by the judge to return a verdict or verdicts with respect to defendants or charges at which the verdict has been reached. And thereafter, the jury may, in discretion of the judge, resume deliberation. That's pretty cool. So the judge can request a verdict, and the judge can also enter a partial verdict and request further deliberation on the remaining counts. So that's also an option. That's pretty cool. So the judge can ask for or receive verdicts at any time and can enter verdicts at any time and then ask for deliberation on the stuff that's still hung. That's cool. I like that. The judge may declare a mistrial as to any charge upon which the jury cannot agree as to a verdict, provided, however, the judge may first require the jury to return verdicts on those charges upon which the jury can agree and direct that such verdicts be received and recorded. Yeah, which makes sense. The judge can ask, but she doesn't have to. So, yeah. There doesn't appear to be anything that makes her. Unless there's some case that says may mean shall, which would not be unheard of. But, do I think the internet should be a utility? You mean in terms of like being regulated under like Title I of the FCC? Yeah, probably. I believe Turtle Boy's mom died the day before the verdict. That is sad. Yeah, hearts out to Tony P, who's recovering from surgery. Tony P is our good mob. We love her. We love our good mod. He's a great guy. Look at Pool of Jewelry. What about... okay. Poll of Jury. When a verdict is returned and before the verdict is recorded, the judge may be polled. The jury may be polled. Well, a verdict was not returned, so it doesn't apply. If after the poll is not unanimous, the jury may be directed to continue deliberations, or maybe it's discharged. Yeah. So poll the jury doesn't apply either. There was no verdict returned, so there's no poll. So that doesn't apply. That's why no poll? Yeah. I understand. Although, to be honest, it doesn't say if you can poll or not in another circumstance. It just says under this circumstance you can. It doesn't say it's the only circumstance in which you can. So if your point is they can't poll the jury, well, this rule doesn't say that either. It simply says when a verdict is returned and before the verdict's recorded, the jury may be polled. It doesn't say whether or not you can be polled in any other set of circumstances. It's silent, at least as to this rule, as to that issue. So if you're reading it that way, you're overreading it the other way. Did I watch the Baldwin motions? No, my power was out. I didn't watch it. My power was out. And I was trying to find food. I found one Subway that had its power on. It had a line of 15 people. I got my Subway, though. Why had she met privately with them and dismissed them before the defense could say anything? I don't think she has to. Because the issue had been argued before, right? The issue is whether the jury's hung, and like they'd already argued the issue like twice. And so I don't think it was error for the judge to be like, okay, there's a mistrial. And having done that, there's nothing particularly wrong with a meeting afterwards, at least implicitly. And even if the members of the jury said, okay, even the jury had said to them, we're not guilty, there had already been a mistrial declared. She wouldn't be able to do anything about it anyway. Have I seen the microdocs video? I don't know what you're referring to. If the jury would have checked not guilty on 1, 3, and undecided on 2, what would have happened? The judge could have accepted the partial verdict, or the judge could have sent them back for further deliberation. If at the end they were still that, I don't know. We haven't discussed that contingency. Yeah, every trial I watch, the judge says thanks. They get certificates. Apparently they got a form for free counseling. That's nice. The 911 call enhanced. I have no particular desire for that. We're going to be on tomorrow, hopefully, with Baldwin. How would eliciting mathematically possible and physically impossible testimony, not suborn perjury, apply a reasonable person standard to the attorney? I don't know. That assumes that the attorney understands physics, I guess. The pro se decision in Sarah Boone, she deserves it. She effed around and found out, ma'am. The judge can't dismiss the case. Only the prosecution can call for an acquittal. No. You're wrong. You're absolutely wrong. The judge can enter a judgment of acquittal. In fact, the defense asked the judge to do exactly that. She absolutely has the power to. What the hell are you talking about? Of course she does. Boone is Samsonite? I think it was Samsonite, yeah. Fun. What do you mean misbites? I don't know what you mean by misbites. I don't know what you mean. I thought the judge had the right to call mistrial once the jury came back after Rodriguez. Yeah, I think that's right. Yeah, I think that's exactly right. Yeah, legal bites. Yeah, I know bites is legal bites. I just don't know what you mean by I'm going to miss her. I don't know what you mean. What happens with the motion? It'll be denied. It'll be denied summarily. Yeah, legal bites is probably miss bites. Yeah, I know who she is. I just don't know what you meant when you said I'll miss her. I don't know what that meant. Legal bites isn't invited or won't join. You mean with respect to the stream we're doing? We're limited to 6 people. And so it became an issue of like who we're going to invite and who not. So yeah, there was a limitation. Yeah, I know that Legal Bites is having a child. That's awesome. Thought she was booted, not welcome anymore? Not to my knowledge. No. Not as far as I'm aware. I've never heard of that. No one's ever brought it to my attention. No. With respect to the Baldwin trial, it's both it's a technical limitation, and also probably for our benefit, then also becomes a practical limitation. So the limitation is that StreamYard only allows you to stream to 6 places at once. Oh, you know what I think? I think I figured it out. I think I figured it out. What happened? I'm gonna have to set up a separate stream just to test it. Earlier, I think I figured out what happened. Anyways, let me finish my thought. I'm sorry. StreamYard only lets you set up 6 streams from StreamYard. So we are limited to 6 people that can stream it. And that's also probably really good as a practical limitation, because anything more than that just becomes unwieldy anyway. So it was Nate and I's idea in the first place, right? So Nate and I formed up this idea together. So this was our idea in the first place. Eric Hunley got in on this because it seemed like a reasonable thing to do. It offered as neutral ground, effectively. It's like, so there wouldn't be like, so that we could, to the extent there had to be an anchor, not that it really matters, but, to the extent there had to be an anchor, we could have neutral ground by having it be on Eric's stream. So he became 3. So him, Nate, and me became 3. So it's like, okay, now we're looking for 3 additional people, right? So we're limited practically. And I think where we wound up was Andrea Burkhart, Ani on Direct, and I'm not sure who's taking the last slot at this point. It might be Joe. I don't know. It might be Viva Fry. I don't know. But yeah, it was a practical limitation. So she's not being excluded just so much as, well, it's not possible really to include everybody. So no hard feelings, at least to me. Yeah. It won't be Runkle. I talked to Runkle. He wasn't interested. Which, fair enough. No harm, no foul. Runkle was not interested in that. So, that's cool. No, that's fine. Can't we rotate the spot like the old days? I suppose we could rotate the spot, but then we'd have to decide a rule for that. And, that becomes challenging unto itself. So, like, what's the rule, right? Who's in and who's out on any given day, right? So this is what Nick Recato would say. It's like anytime you have a group, now suddenly you have an in group and you have an out group, and politics become a thing, right? So it's like, yeah. So like, obviously we could rotate the members, but who, when, how, and so forth and so on, right? It's like, yeah. Runkle's covering it himself. That's my understanding, yes. Which is fine. No hard feelings. Hogue? Nah. No. I don't think Hogue would be interested anyway. with his stroke, I don't know that he would have the endurance for multiple day streams like that. So I don't think so. The limit was 9. The restreaming limit is 6. You can have, I think, actually 12. I think the limit for number of people on the group is 12. So you can have 12 people inside a StreamYard group, but the limit to restreaming is 6. So you can only have 6 going streams, outgoing. Right? So in the past, there would just be one outgoing stream, right? When Nick Rekieta hosted it, there was one outgoing stream. It was on Nick's channel. When Legal Bytes was hosting, it was one outgoing stream. It's on Legal Bytes' channel. But now what we're talking about is having 6 outgoing streams, right? So we're all streaming the same stream at the same time, all on our own channels at the same exact time. And so, yeah. So that limitation is 6. So we could bring in more people. We just can't increase the stream count. So that's what we're limited to. But I have a cheat. And that's what I was trying to set up earlier, because I paid for a month's membership on Restream.io, which allows for a custom RMTP server. So from StreamYards, I can set up one stream to Restream. And then from Restream, I can split that stream 5 different ways. Yeah, I'm just that good. So I can take my one stream and I can, on my end, split it 5 ways so that it'll be simultaneously streamed on YouTube, Twitch, X, Facebook, and LinkedIn all at the same time, because I'm just that good. Yeah. Yeah, restreaming or restream. That's right. Restreaming or restream. So, should be entertaining. Is Twitch going well? Reasonably well. I think we had 70-something plus subscribers. I'm not sure what the count in the back says, but it's going fine. And the more I use it, the more that will increase. So, plus it costs me nothing. Well, I guess it cost me the $19 for the month's membership, but that's okay. So, who's Kurt talking to you? I'm talking to you, Thunder Snow. You're the light in my eyes, baby. No one else. You and me together. Do I want to connect with the UI guy? I don't know. That's something I have to discuss with the group now. It's now a group decision. All right, I think I'm going to end the stream. And then I'm going to do a little test stream later to see if I figured out what the problem was, because I think I have. Maybe. So I'll give myself a little R&R, and then I'll maybe do a little test stream later to see if I figured out the issue. I haven't forgotten our wager. I still got my $10 ready, but we may not find out the answer for a while. So what do we got? 1395 followers, and what are we in terms of subs? 70 subs? Nah, it's not bad. 70 subscribers, not bad, man. And we're making progress. Yeah, so I'm happy with that. I think that's a good number. All right, guys, I'm going to sign off for now. I will talk to you later. Bye-bye for now. They did have a not guilty box for all 3 counts. Giselle, I swear to God, one of these days you're going to listen to me. They did have a not guilty box for all 3 counts. Please stop spreading this rumor. They had a not guilty box for all 3 counts. Get off my lawn.